Hello guys, welcome to another episode of my lecture. Yeah, so in our last class I did not wipe the board off because we are still talking about rules governing exclusion clauses under unsigned documents. Because that is still the subject matter of what we are talking about, then all these things are still relevant to us, because we still will talk about, just a recap of the last class, but we still will talk about the rules as stated by Parker versus Southeastern Railway Company. And what are those rules? Where there is a writing on a ticket and the person does not see the writing, doesn't acknowledge the fact that the writing is there, what's going to happen? Then the person is not bound. Just to be sure that the sound is working properly, just a minute. Yeah, so as I was saying, sorry for that, I just wanted to be sure that the sound was working. So yes, and now I have ascertained that. So yes, as I was saying, if the person doesn't see the writing, what happens? Then this person is not bound. But if the person knows that there is writing and then also knows that it contains condition, then the person is bound. Then if the person knows that there is writing but doesn't know that it contains condition, then we have to look at what type of document it is. If it's a contractual document which is naturally supposed to contain what is it called, conditions, then the person is bound. But if it's such that it's not a contractual document which normally does not contain conditions, then the person will not be bound. Now, which goes to our fourth one, except the other party then gives the person reasonable, takes reasonable step to give the person notice on it, and that person will be bound. So this is just a recap. If you don't know what I'm talking about, then there's no point continuing with this class, because this class is a build-up of the last class. So you need to go and watch the last class first, understand how we built up to this extent and how exactly we intend to proceed from this point. So these are the cases. We also looked at the case of Odeni versus Zad, and we looked at also that of the contractual document rule, that if it does not form part of the contractual document, which is talking about rule 3, if it does not form part of the contractual document, then it cannot be said, the person cannot be said to have notice of the content. Yes, so and then today we are going to start with our first Nigerian case of Iwuha versus Nigerian Railway Company. Iwuha versus Nigerian Railway Company. But before I go and before I start my class for today on this, standing before you is Olayeni Diekolola Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode, like I said, we are talking about the part 2 of this, and then we go straight to what we have to talk about today. Now, in the case of Iwuha versus Nigerian Railway Company, the plaintiff appellant delivered 3 packages to the respondent at Aba for conveyance to Buruku near Jos. After paying the freight, the appellant was given a waybill containing the following words. Now, I need us to understand something. Now, it was after he paid for the flight, yeah? It was after he paid for the flight, the freight rather, not flight, because the freight will be for the goods. This is spelling of the freight, right? Not flight. It was after he paid for the freight rather, that he was given a waybill. And normally waybills are contractual documents because they give you conditions of, the whole shipment and all that. So he was given a waybill, and what was written on the waybill is that all tariffs, whether passenger, luggage, parcel, goods, livestock, etc., are carried subject to the Nigerian Railway Corporation Act 1955 and the tariff regulation made thereunder, copies of all of which are available for examination free of charge at every station. This document is evidence of contract as well as acknowledgement of any money paid. It was saying that this document is what is it was written, the waybill there, it was written on the waybill that he was given. 3 things were written that you need to understand. Number 1, he said that all tariffs are subject to the Nigerian Railway Corporation act. Whatever the act says, all tariffs are subject to it. But I don't think that's the part that we need to. The part that is very important is that tariff regulation made thereunder, copies of all of which are available for examination at. So it's telling you that what you are currently doing, there is another regulation that you are supposed to look at that talks about this your contract. Do you see? In the way bill, it referred to another document, right? And then he also said that this document is available at every station. Then he also said that the document is part of this document is evidence of contract as well as acknowledgement of payment. So he's talking about the way bill now. The way bill referred to the Traffic Regulation Act, if I'm correct, the tariff rather, not traffic, the tariff regulation. The Nigerian Railway Corporation Act, the Nigerian Railway Corporation Act, and also talked about this tariff regulation, which was available, a copy of which was available at every station. So here, in this case, now we have a way bill. This is our way bill, right? Inside the way bill, then you have a condition that relates to another document. This is the other document, and it's telling you that this document is part of this thing here. And also, if you want to see this document, you can find it in every of our station. So this way bill is referring to this, and because way bill is a type of document that forms under contractual document that you naturally expect to find conditions. Therefore, it is taken that you should have looked at it. This one, where you have a way bill, a way bill that has writing, then it is taken that you are supposed to know the conditions, right? It is taken that you are supposed to know the conditions here, and therefore you'll be bound by it. And then this way bill now told you that there are conditions in this other thing here. Do you understand? So when the train arrived at Buruku, it was discovered that 2 of the 3 packages were missing, and the appellant, claiming that the packages contained wearing apparels, brought a claim for 40,000 naira against the railway company. You should know that this is an old case. So in our day and time, it's going to be about 40 million. So now the corporation denied liability for the 40,000 naira, claiming that its liability was limited to 40 naira. Now, it relied on the content of the tariff regulation number 9 of 1891, which inter alia, when you are seeing inter alia, it means amongst other things, which amongst other things limited its liability to 20 naira per package, unless at the time of the consignment the value and content of the parcel or package have been declared in writing by or on behalf of the consignor. In that case, the corporation was entitled to impose an additional charges, or in cases where the value of the parcel exceeded 1,000 pounds sterling, to decline to accept liability beyond 10 pounds sterling. In addition to the above, under the regulation tariff or the tariff regulation, the corporation was entitled to certify itself that the parcel actually contained the declared good, and that they were of the declared value. Now, I need you to understand what we are talking about here now. So we are saying that according to this tariff, don't forget that this way bill that he was given, after he paid, they gave him a way bill. It is said that way bills are part of a contractual document, so he's deemed to know the content of the document. But the only thing is that the tariff regulation which they want to rely on wasn't given to them, but the way bill referred the tariff regulation. He said that you should look at the tariff regulation, which you would find where in every of our station. That tariff regulation now restricted their liability to 40 naira. They are bringing a claim of 40,000 naira, and then the tariff regulation restricts their liability to only 40 naira. Can you see where we are beginning to have a problem here and there? So now the next question for us to ask, is, would this person who had the way bill be bound by this 40 naira thing. Do you understand? Which he was not given, but he was told, he was referred to from the way bill too. Now, what did the court say? In light of the above, the Supreme Court held that the way bill was a contractual document, and I told you, if you look at it from here, if there is writing and it contains condition, whether or not you saw the condition will be subject to the kind of document. If it's a document that is a contractual document, then whether or not you saw the condition, you will be bound. But if it's such that it's not a contractual document, then you will not be bound. But you'll be bound if there is reasonable this thing. So because it was a contractual document, the court was already telling us that he will be bound. So in the light of the above, the Supreme Court held that the way bill was a contractual document and that the appellant was bound by content. Secondly, that the conditions contained in the Nigerian Railway Corporation Act and the tariff regulation made thereunder were incorporated by reference into the contract of carriage of goods between the parties. Consequently, the appellant was only entitled to 40%. So he said that because it is a contractual document, whether or not he read the way bill is none of our business. So far it's a contractual document, then we have C. Do you understand? I told you there are two types of documents here. If you know that there is writing, for whether or not you read the conditions in the writing would depend on the type of document. If it's not a contractual document, then they must take necessary steps. But if it's a contractual document, then you'll be deemed to know the content of this thing. And the way bill is a contractual document. Although you were not told, you were not given this, but by reference, it was incorporated. So therefore, you had notice of it by reference, and therefore you are bound by it. So if you can see a problem question in exam where they are going to use this whole incorporation thing, the moment you see that, you know that this is your authority. That is Iwuha versus the Nigerian Railway Corporation. This is your authority where you begin to see incorporations into documents. That means that they incorporated one document into another document. That document that they incorporated it to is a contractual document that form part of the contract. Then the person, whether or not he read that document, will be said to be binding by the whole of it. Do you understand? This and that. So way bill being a contractual document, then whatever this says is binding here because he already made reference to it. Do you understand that? So now to continue with the notes, the decision of the above case, Iwuha versus Nigerian Railway Corporation, may be contrasted with the decision of the Court of Appeal in Cabo Air versus Staffa. Cabo Air versus Staffa. The respondent brought a ticket for a flight from Lagos to Maiduguri from the appellant airline. When he arrived to board his flight, he was not given a seat. He sued for breach of contract. The defendant or the appellant denied liability by relying on a document containing the terms of and condition of the contract, which had been brought to his notice when he bought the ticket. What did he say? Which had not been brought to his notice when he bought the ticket. So now what we are talking about is that they were flying, they were supposed to be an airline. Then he got to the airport, and then he bought the ticket and everything, and then they didn't give him a seat. They told him no, and then he bought. So he brought an action for breach of contract, which everybody will say, that is a breach of contract. You paid, right? And they have not fulfilled their part of the agreement, right? That's a breach. If it's not even a fundamental breach, because the essence of buying the whole thing is because you wanted to fly, and then now they are restricting you from flying. So that would be said to be a fundamental breach, right? So, but then the other parties are saying that, there is a condition stated in one document, but that document, according to the fact, was not brought to the notice when he bought his ticket. Those terms could only be viewed at the main office of the this thing. So when he bought the ticket, there was no reference to the document when he bought the ticket, and those documents, those conditions and all that, can only be viewed in their main office. So what did the court say? The Court of Appeal, affirming the decision of the High Court, held that document E, containing the terms and conditions of the contract, was not a contractual document, and the airline could not rely on it to avoid liability. The court stated that a close look at clause 3 of Exhibit A reviews that the content can only be made available to the respondent on application at the office of the appellant. It would mean that at the time of the contract, the content of Exhibit E, which were the terms and conditions of the contract, were unknown. If that is so, this cannot be said to form part of the agreement between the appellant and the respondent. At the time Exhibit A was being purchased by the respondent administrative manager, Exhibit E had not been disclosed, the respondent could not have accepted to be bound by the content of Exhibit E, which were unknown to him. It does not apply to the contract between the parties. It is meaningless. It ought to be ignored. So this is what they are talking about here. He went to buy the ticket here, although you are here in Exhibit A and Exhibit E. Don't get confused by that. He went to buy the ticket, and at the time he bought his ticket, it was not written on the content of his ticket. There are documents restricting liability of all passengers. Quite all right. That's the restricting liability of the airline from all passengers, like they will not pay for this, there will not be breach of contract in the event you don't fly, and those kind of things. That's no problem. But if those documents exist, those documents must be incorporated in the transaction. They did not incorporate it like what Iwuha did in Iwuha versus Nigerian Railway. What he did in that case is that there was a way bill. Yes, there are other documents. Those documents are in their offices, no problem. But in the way bill that they gave to him, they notified him there. Even if the way bill is a contractual document, the contractual document only makes the party bound by the content of that contractual document, but not by any other content. If you want them to be bound by any other content, you must incorporate by reference that other document exists. So he went to buy a ticket, he bought the ticket, and then he went to. There was no incorporation, there was no reference to anything. Now when he got there, and then there was what is it called, they did not let him fly, which is a breach. Then he wanted to sue, and they were like, oh, well, you can't sue us, sorry about that. Why can't I sue you? Oh, because there's one document somewhere in one of our main offices. So when you get there, you will see the document. But I did not know that this document in fact existed, you see, because you have to bring it to the knowledge of the party. So even if it had been a contractual document that they gave to that party, but they did not incorporate that other document in it, it still wouldn't fly. It still wouldn't fly. So there are two things that you must do in relation to this, where the document is a contractual document, right? So if the document is a contractual document, which is this third rule that we're explaining, where there is a writing, and that writing contains document, whether or not it will be bound will be dependent on the kind of document it is. If the document contains conditions, whether or not it will be bound will be dependent on the kind of document it is. So if it is a contractual document, then he will only be bound by the content in the contractual document. If you want to relate to other documents, you must bring it by incorporation and reference. If it's not a contractual document, he will not be bound, except you took reasonable step to let him know that there are conditions in that document. Do you understand the difference now? So in this case now, there were some conditions somewhere in the office. They did not incorporate it in any contractual document and gave him notice of it. No. So the court held that he was not bound by whatever was sitting all around in the office. You know, it doesn't work that way. So the difference between the two cases would appear to be that in Iwuha's case, there was an express invitation in the way being to Iwuha to read the tariff agreement containing the exclusion clause. You see that? While in Tafa's case, there was no such express invitation to read the document containing the exclusion clause. Now, according to the court, it is emphasized that the respondent could not have freely entered into a contract and agreed to be bound by Exhibit E, that is the terms and conditions of the contract, which was never brought to the respondent at the time the contract, that is buying the ticket, was made. So you were buying the ticket. They did not tell you that one terms and condition is sitting down somewhere in their offices. They didn't even tell you that it existed. So when you are buying this thing, and then when you are done, and then they breach that, oh, you should have gone. No, how do I know that it existed? It's your job to let me know that it exists. Do you understand that? It's your job to let me know that it exists. And that is what they did in the way bill. There was one tariff regulation sitting down somewhere, but they did not just say it's sitting down somewhere. If they had not incorporated it into the way bill by saying that this way bill is subject to the tariff regulation which is available at our offices, then that tariff regulation would not have been binding on Iwuha. But it became binding because it was incorporated in that contractual document that he was given, which whether or not he reads is not relevant, as much as whether or not the document, the contractual document, well enough to have given him notice of the content. So if they've given him notice of the content in the contractual document and they've incorporated it by reference, he is bound. He is bound because they've referenced it and they've incorporated it into the contractual document, which they did not do in the case of Cabo Air versus Staffa. I hope I got that correctly. Yeah, Cabo Air versus Stafford. So we continue with the notes. Now, it should be noted that in the car park cases, particularly, a large, well-displayed notice of exempting the owners or of the premises from any liability for loss or damage is binding and effective. In the case of Imo Concord Hotel versus Aya, a case involving the loss of respondent car in the appellant car park, Edozie JCA stated that the duty of the car park owner would have existed. It could be excluded by the occupier by the exhibiting of the appropriate notice to the effect. So when you get to car park, and you can see there are a lot of car parks that actually do it. Even not even car park, where they charge phones, they also do it. Where they repair phones and all that, they write it there in the office, especially when you're charging. Phone charge that owner's rig, the shop owner will not take liability for any loss, and they write it there. It's glaring. Do you get? So once you can see it, the moment you enter their offices, once you can see it, the moment you get to the car park, once you can see it, that thing, that notice is binding on you. They will not be liable. Do you get? That is the essence of all those things that are written. They will not be liable. So let's go further. Now, from what has been stated so far, it is clear that if an exclusion clause is to be effective, notice of it must be given to the other party before the contract is concluded. This is in fact the main point about the non-contractual document, particularly receipts and a purchase ticket, I think, and perhaps tickets rather. So when we are talking about contractual documents, why we don't call receipt contractual documents is because they are usually gotten after the contract has been concluded, so they will not be regarded as this, and they are just tickets as well, are used to evidence payments. They are not used to show that they are part of the document of the transaction. They are only used to evidence payment, and in that context you cannot call them contractual documents. So when you are looking at this stored rule as to what type of document it is, I think it's very important for us to understand contractual documents. If you are looking at contractual documents, you look at what kind of document is it. Is it trying to evidence payment? Is it trying to show something? Are there terms written in it? If there are terms written in it, then it will be part of contractual document. And once it's a part of contractual document, then the other party, whether or not he reads it, he will be bound by the content. But if you are trying to incorporate another thing into that contractual document, you must state it expressly there, because if you don't do it, then now that party will not be bound rather by the this thing in the other this thing. So that is the Cabo Air versus Stafford. So, however, let us look at another case of Ole versus Ole OLLEY versus Marlborough Court. Ole versus Marlborough Court. Now, a husband and wife arrived at a hotel and having filled the usual forms and gone through the usual formalities, they paid for a week's residence. On getting their room, they found a notice on the wall stating that the hotel would not be liable for any loss of article not submitted to the manageress for safekeeping. In answer to the suit by the wife for the loss of her forecoat in the room, the defendant claimed that they were protected by the notice in the room. The court held that the contract was already completed at the decks before the couple saw the notice. Now, I personally do not agree with the court here. I personally do not agree with the court here, because yes, the court was correct. It was after the okay, let me give you the facts now. So we are talking about two people. They went to pay for hotel room at the reception desk, right? They paid for hotel room for 7 days, right? And when they got into their hotel was when they now saw a notice that if anything missed in your room, we are not going to be liable. And then something missed in the room. And then the court said that, because it was given to them, the notice was given to them after the contract has been concluded, it cannot be binding. But me, if you are following Parker's case, even when it was given to them after, if there is reasonable step, that's why if there's a ticket, if it is not a contractual document and then the notice was given to them after the contract has been concluded, then there must have been reasonable step, necessary step to let the other party know that that particular exclusion clause exists, and it was written in their room. They got there and they saw it was glaring. Do you get? So at that point, I feel that they were bound by the exclusion clause, but this court seemed to say no, because it came out after the contract has already ended, like they've concluded the contract. That's when they now saw it that it cannot be binding on them. That was going to go against what Parker's case is saying in itself, which I personally do not agree with. So where there has been a couple of dealing between the parties is another rule. Where there has been a couple of dealings between the parties, the injured party could be held bound by the exemption clause. The injured party could be held bound by the exemption clause, even though on the particular occasion he only received notice of it after the conclusion of the contract. He would be imputed with notice as a result of his previous dealings with the people relying on the exemption clause. It should be noted, however, that for the injured party to be bound on the basis of previous dealing, it must be established that he had knowledge of the actual terms and not merely that he knew that there were conditions, if he never bothered to read them. Now, in the case of McCutcheon versus McBrien, McCutcheon versus McBrien, McBrayne. The defendant's ship sank when ferrying the plaintiff's car across the sea, causing the loss of the car. Also, it was established in evidence that the plaintiff had carried out this transaction in a number of occasions, and that on the same occasion he has been asked to sign a document exempting the defendant from liability for loss, whilst on other occasions he had not. On the occasion he signed the document, he never bothered to read them, although he realized they must contain some condition. It was held that in spite of the previous dealings, the agent could not be imputed with the knowledge of the exemption clause, where he had never read the document and therefore had no actual knowledge. Now, what they are trying to tell us here is that, let me explain it here. So there have been three different dealings, three different occasions, right? So on the first occasion, let's say the person signed an exemption clause. He didn't read it, they just brought it to him and he signed it. Take it back. Second occasion, he signed. He didn't read it, but he signed the exemption clause. Take it back. In this third occasion, now, in these two occasions, the car that he was importing through the ship did not capsize. So obviously the exemption clause did not operate. This second occasion did not capsize. Obviously it did not operate. On the third occasion, they did not give him to sign. But he knows that there is something wrong. Battery 20%, but he knows that there is something wrong, right? He knows there is something wrong with because he usually signs something, so he knows that there's a writing that he signs. Now, what the rule is saying is that it was held that in spite of previous dealing, the agent could not be imputed with the knowledge of the exemption clause, since he never read the document and therefore had no actual knowledge of their content. Because in this third one, if you want to bring evidence of previous dealing from this one, for this new one, where he did not sign, we are talking about unsigned documents. If you want to bring, then you must show that in those previous dealing, he knew the content of the document in this third one. Now, let me just let you know, if this thing had happened in the event that he signed, whether or not he knew, if it happened here, whether or not he knew is very, very inconsequential, because he signed. So whether or not you read it is none of our business. You signed, is binding, because the car got lost in the middle of the ocean. But that didn't happen when he signed, first and second. Now in the third, he did not sign. So they now want to bring evidence of previous dealings. Do you get? They want to bring evidence of previous dealings and say, my lord, see, in as much as he did not sign this time around, right? And they did not let him know anything. But this guy is our guy. We used to contract normal. The first time he signed, look at it, he signed. The second time he signed. But the fact that he signed the first time, the second time, does not mean that he knows the content of the document that he has signed. The thing that you also have to put in evidence is that not only did he sign, he also knew the content. Those two things will now be binding on him for this third one, where he did not sign and where he did not have any documents to the effect. Do you understand? That's why the court said that it was held that in spite of previous dealings, the agent could not be imputed, the person here could not be imputed with the knowledge of exemption clause, since he had never read the document and therefore had no actual knowledge. He never read the document, he just kept on signing. Yes, there are previous dealings where he signed, but in this case, you cannot impute it except you can show that in those previous dealings, not only did he sign, he also read the document. That is the only time it will be in operation in the third dealing. What's our authority? McCutcheon versus McBrien. Right, so we go to our last set of rules where we are going to be talking about illiterates and all that. So let's go straight to the point. Now, is there any separate rule regarding notice of the existence of an exemption clause applicable to illiterate parties to a contract, apart from the special conditions laid down in the Illiterate Protection Act, which we shall deal with later? It appears when I say deal with later, I'm talking about when I have classes on capacity to contract, illiterate capacity to contract. Now, it appears that the degree of notice necessary to make an exemption clause applicable to an illiterate is higher than normal. So let us look at our first case of So yes, sorry for the little break in transmission. I'll try to be as fast as possible. We are already at the latter part of the class. Let me just check one more thing. So yeah, we are talking about illiterate here, and if you look at this case of Cabo Air versus Lito, all the court held in this case is that there was a consignment of ship from Lagos to Ghana, stuff like that, but at the end of the day, they gave the other party a receipt, and the other party was an illiterate. So in the case of illiterates, the court held that not only are you supposed to, that it's a contractual document, it's not a contractual document because it's a receipt, so not only are you supposed to bring that condition to that other party when you know is what is it called, when you know that is an illiterate, then you're supposed to look at the condition, right? You are supposed to be able to convey that condition to him because you know he cannot read from the book. So if he is an illiterate, you have to take a higher reasonable step. For example, if the normal reasonable step you take for any other person, Oga, for that book where you hold that receipt, conditions dey the back, kindly, or you see this one that they said, the other one, yeah, they said see back, in the back there were conditions, sure you get. So normally whether or not that see back will constitute reasonable, this me I don't think it will constitute. I feel that you should let him know. So Oga, at the back of your receipt you are going to see conditions, you are going to be liable, we are not going to be liable for so and so. So now you don't need to tell a normal person what the conditions are, you just need to tell him that at the back of that thing there are conditions. That's reasonable step to let a general person know that there are conditions. But for an illiterate, telling him that there are conditions is not enough because he can't read the conditions. So you need to let him know the exclusion clause for that, and that is what the court in the case of Cabo Air versus Lito is basically telling us. And then if you also look at the case of Richardson, Spencer and Co versus Ronnie Ray, I hope I got that right. Now, where the plaintiff, a passenger in the defendant's ship, was injured in a journey from Philadelphia to Liverpool, the defendant tried to escape liability by relying on the exemption clause in her ticket. Even though she knew that there was writing on the ticket, she did not know it contained condition. In affirming the lower court judgment that the defendant had not done all that was reasonably necessary to give the plaintiff notice of the condition, the House of Lords took into consideration the fact that the ticket in question was for a storage passenger, a class of people of the humblest description, many of whom have little education and all that. So in this case, she knew that there were conditions. She knew that they were writing on the ticket, but she did not know that it contained conditions. So this is it. She knew they were writing, but she did not know that it contained condition. So the next question that we need to ask is what it was on a ticket. Because it's a ticket, it is not a contractual document. Do you understand? It falls under not contractual documents. So therefore, you then have to use the reasonable rule. Did you reasonably tell her? And even if you are reasonably told her that there was condition, because she's an illiterate and she couldn't have read, you still have to tell her what what that exemption clause is. Thus, although the question of a higher degree of notice of the existence of an exclusion clause for illiterate people has not arisen in recent times, this issue is still of great relevance in a country like Nigeria, which despite great strides in education still has a very low literacy rate. That is where we end our class for today. So we've gone through everything that we need to go through on the subject matter of what? Of exclusion clause for unsigned documents. Exclusion clause for unsigned documents. We've gone through everything that we need to go through. We've gone through the first part where we talked about the conditions and all that. We also told you about the contractual documents. I've told you about the illiterate and when it will apply. I've told you about when you want to apply to previous dealings and all that and all that. We've basically gone through everything. So my next class, we are going to be talking about rules guiding exclusion clause under signed document. Rules guiding exclusion clause under signed document, and we are going to have a thorough discussion of that in my next class. Thank you for watching to the end of the class. I will see you in my next class.